For those of you who are writing the Canadian Administrative Law exam, I noticed that the NCA had changed the syllabus for June 2023, and I was reading the syllabus to update Law Study Kit notes and noticed that the examiners did a really good job in explaining what is important for the exam and what are some of the things that you should really take into consideration. So I'm not sure if you've actually read the syllabus, but if you are someone who is going to write the admin law exam in the upcoming months, I highly encourage you to read the syllabus at least 2 to 3 times to understand what is it that the examiner actually wants you to do. And to me, it sort of looked like the examiners really want you to pass the exam because they put warnings towards the end of each concept. Actually, the most important concepts, they put warnings that, don't do this or make sure you're doing it the correct way. So I'm going to talk about 3 warnings that I found were very interesting and something that you should actually pay attention to. Page 6 of the new syllabus, the examiner talks about procedural obligation triggers. So basically, when is procedural obligations triggered? So when does it arise? And in the section about warnings, the examiner clearly states that before you get into the common law concepts of procedural triggers, it is important to look at the statute. So it's important to take a look at the statute. What does the statute say about this? A lot of times students forget that and they jump right away into the case law and the analysis, which is good, but if you don't look at the statute, you're telling the examiner that you don't entirely understand the process. And on the syllabus, the examiner also clearly states that when you are looking at the statute, make sure you read it properly. The way that I would read it is, who does the statute apply? How does it apply? When does it apply? And, if there are any timelines or limitations. So who, what, why, when. That's the way I would look at a statute, and if it's not applicable in a scenario, you can then move on to common law triggers. But it's a very interesting thing that the examiner has brought up, because when I was studying for my admin law exam, I made the same mistake when I was practicing exam questions. Because I was reading cases and I was trying to understand a lot, case law and precedents, I kind of skipped the main step, which is first, you're going to look at the statute to understand whether any procedural obligation has been triggered or not. So page 6, read it properly, make sure you understand it, and highlight stuff that the examiner actually, is asking you to do. So the examiner has said, please do this or don't do that. And, I would highlight it and make sure you understand it. On page 9, the examiner talks about content of procedural fairness. So in very simple terms, what kind of fairness or what kind of procedures are we referring to? So for example, right to be heard or right to an unbiased decision maker. These are some of the contents of procedural fairness as stated in the syllabus. But if you go down and read warnings, the examiner states that don't blindly write about all of the contents of procedure fairness. Because if you do that, you're showing the examiner that you don't really know what content of procedure fairness applies to the situation. So if you blindly write down what you have studied and you're not really analyzing the facts and see which content of procedure fairness is applicable in the scenario, you're not fulfilling the objectives of the course. So in this situation, when I do some consults for Law Study Kit, I had somebody ask me this question, and I always tell students that if you get a question, you have to kind of think back and see, does it involve a similar scenario that you have read about? Most likely in a case or in the book, and what discussion was done in that particular case. So it's a good idea to first read the question properly and see which content do you think is most applicable here, and apply and talk about that. But don't write down all of the contents, because it shows the examiner that you don't know how to answer a question. You're just kind of writing down answers which you've learned. So there's no analysis involved. This aspect of admin law is extremely important, and this is something that I would pay a lot of attention to. So highly recommend that you read this section as well, because again, it tells you what to do and what not to do. Page 12 of the new syllabus talks about standard of review. And this is something that I feel like I've talked about previously as well. But again, in this section, the examiner clearly tells you what standard of review means, what standards are there, and what are they expecting from you in 2023. So when I was writing the exams, we had to discuss old case law that is no longer applicable now. So it's important to understand Vavilov decision, which is a very important case, as well as Bell Canada. These are two cases that if you don't understand them, it's important that you try to read up articles on it or try to just Google summary of these cases, because these are very important concepts in admin law. And the examiner also states that they don't expect you to write down about history. So history is history. You don't need to discuss previous cases. However, previous case law is important to understand intention. Why are these cases decided the way that they are? What is the reasoning behind it? So while you may study old case law in the book, but when you are actually attempting the exam, do not talk about older case law when you're talking about standard of review. Make sure that you understand Vavilov, you understand Bell Canada, and in the 2023 syllabus, there's also another case that has been added, which was a very interesting case. I'm going to write it down here because it's a little bit difficult to pronounce. So I'll write it down here, but that was a very interesting case, and it actually involved immigration, which is an area that I practice. So I was very interested in that case and the judgment and how the standard of review was done and what the court said. So again, make sure that you understand this and you know that you're not spending and wasting your time on discussing something that does not apply anymore, because you don't have a lot of time on the exam. And if you spend that time discussing something that's not required, you're likely not going to get marks for it, and that could be a problem. Good luck for your exam. If you're somebody writing now or after you've watched this video, make sure that you read the syllabus. If you are looking for sample questions and answers, I have drafted sample questions and answers at Law Study Kit. I will link it in the description box below. I have drafted the questions myself and the answers myself too, and I discuss case law, how to make sure that you're writing precisely. So if you are interested, feel free to check it out.